Hi everyone, Harry here to talk about one last important opinion that the Supreme Court issued today, namely Fischer versus United States, which is of some moment in itself and concerns potentially, though I think not, as it turns out, so profoundly in actual operation, all the conduct of the January 6th marauders. And also, and more importantly, in the focus that everybody has waiting for this opinion to come out, potentially charges against Donald Trump in the January 6th case. So Trump is charged under 1512 C2. This will get a little legal, but not so bad. Hang with me. Having to do with obstruction for his, generally speaking, the effort to impair the January 6th proceeding. And Fischer, the guy who was in the Supreme Court, was similarly charged. But Fischer, basically, it seems to be, it'll now be on remand, and the government could try to argue otherwise. But let's say, just for purposes of understanding the case, he's a guy who just, joined the party, as it were, and was part of the melee, and he certainly harmed police officers and has been separately charged for it. But did he impair mean to obstruct the proceeding? And that question for the court was really coupled with the provision before the C2, which is C1, which basically says it's a crime if you, and it focuses on evidence or documents if you alter or mutilate or destroy or conceal physical evidence. Okay, so that's what C1 says. And then C2 says, or if you otherwise impair an official proceeding. And so the argument in the court between dissent and majority was about whether that otherwise, does that mean that, look, it says you impair any official proceeding. So certainly a guy like Fischer, who's one of 1,000 people charging the Capitol and the like, is impairing it. Or does otherwise kind of piggyback on that previous provision, C1, so that what you're doing needs to be otherwise, besides, as the list in C1 goes, destroying, altering, mutilating, evidence about a official proceeding. Basically, do you need some evidence or piece of paper that you're messing with, or is it an all-purpose statute that gets at any kind of impairing of an official proceeding? That's the argument in the court. And the 6-3, the court says the more narrow reading, so it really has to concern, as C1 does, trying to impair or impede some evidence or document. Very interestingly, the dissent, the plain meaning dissent, is authored by Justice Amy Coney Barrett and joined by Kagan and Sotomayor. So it's going to be among the sort of exhibits that people examine when the dust settles on the term to say, Amy Coney Barrett, maybe she's, staking out a position even slightly to the left, of Kavanaugh and Roberts, who themselves are distinctly to the left. But anybody that's so is Attila the Hun of Gorsuch, Alito, and Thomas. Okay, so they hold that you need to be impairing in some way other than altering, mutilating, etc., some kind of evidence. All right, so the obvious question here is two obvious questions. What does it mean for the 1,000+ defendants, many of whom have been charged with under C2 in the whole January 6th melee, and more to the point, what does it mean for one Donald Trump? On those other defendants, the same theory I'm about to give you for Trump may apply for many of them, in which case I think it would mean nothing. But even if it doesn't, there's a pretty good article that just came out in Just Security that canvasses all kinds of criminal statutes in the DOJ's quiver, and suggests that for what we're talking about that those marauders did, they can still be reached. But back to Trump and also the 1,000, at least, who know what they're doing. Remember what Trump's charged with: basically trying to get Pence to throw out the valid electoral certificates done by the actual Trump electors, and substitute for them the phony baloney ones that have been done around the country with the United States proof would suggest his knowledge as part of a conspiracy. And, we're seeing charges really proliferate now in Arizona and Michigan and Georgia, etc. And it seems to me straightforward, and Justice Jackson's concurrence basically makes this point, and I think very purposely, that Trump he's not destroying, he's not mutilating or altering the electoral certificates, but he is otherwise impairing them, right? I think there's sort of no other argument than what he's trying to do is mess with, impair, obstruct the operation of these pieces of paper that Pence opens the envelope and reads out. That's exactly what the conspiracy charge is. And then there's one count of actual obstruction as well, which doesn't require that this have actually succeeded. So the Fischer case, another case in the court's kind of pronounced tendency to narrow statutes that they are concerned could reach, here at oral argument. What about a really vehement demonstration or clear First Amendment activity? Of course, the argument there would be, if it's First Amendment activity, that you can't reach it. It's unconstitutional. But nevertheless, this is their argument about congressional intent. Surely Congress wouldn't have meant blah, blah, blah. And Amy Coney Barrett for Kagan and Sotomayor said, what do you mean, surely? Look at the words they wrote. Surely they did. Anyway, an interesting debate, especially given the personnel, but one that I think does not serve in any pivotal way about Donald Trump or getting off those charges. I think the way this will happen in practical terms is there'll be a remand. Trump is now, once the immunity case is finished, at some point, and soon, he'll be back in the district court before Judge Chutkan. He will move to say, hey, you got to dismiss my 2 obstruction counts, the conspiracy and the attempted one, because of the Fischer case. And I think Chutkan will, the Department of Justice and the special counsel will take much the same position as I've articulated. I think Chutkan will agree. And then the D.C. Circuit, but it would only come up to them after conviction, will agree. Many years down the line, could the Supreme Court do something weird and wacky? Well, as this week shows, this Supreme Court can always do something weird and wacky. But what they've done to date, I think, doesn't serve to give Trump high hopes that his 2 of the 4 counts in the January 6th indictment should be dismissed. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.